We're going to have a speaker come up, Sara G, and she's a Social Security disabilities attorney focused on Social Security disabilities law. Lots of experience working with the administration and medical providers and patients. So it's excellent that we were able to have her come out and speak to the group. Questions around research, I'm sure that they're percolating as you've heard all that stuff. We'll have a session this afternoon as well where we'll do a panel and a Q&A, and so save some of those. Also, after this next presentation, we will be having a lunch break, and I'm sure there's going to be opportunities to have some individual conversations for there. But with that, I'd like to introduce Sara Khaki, and
good morning. My name is Sara Khaki. Thanks for the presentation. And I'm a Social Security disability attorney here in the Atlanta, Georgia area. This is my sole niche, my sole practice area, what I've devoted my legal career to, because it's very close. It's very close to my heart. This practice area. Reason being, when I was a kid, my mother was diagnosed with terminal cancer twice. Once at the age of 5 and once at the age of 12. I'm very fortunate to say that she survived. But thank you. I don't have any family members that have gone through the disease you guys are struggling with, but I do understand what it's like to have a family member that is struggling with their health and how that can affect the entire family unit mentally and financially. I like to say that I get my clients through the Social Security disability process personalized legal care, and that term personalized legal care really matters to me because my clients find me at probably the most difficult time in their lives. They're not able to work due to their health condition, so they're strapped for cash. It means probably they can't afford medical insurance, and their health is declining, and this process that the government puts them through, as you will learn from the presentation if you haven't already experienced it on your own, is very tedious and technical. Most parts of the country, it takes about 2 years, if not longer. So it's not just my job to get them through this process successfully on a legal standpoint, but it's also my job to mentally and financially prepare them for what to expect. And that's really what I'm hoping you guys will take away from this presentation today, is what you can expect from this process and some tips on how to successfully get through it. So the agenda for today is we'll first discuss how disability is defined in the realm of Social Security. And then we'll go over the 2 different benefits that exist in the Social Security disability program. We have regular Social Security disability benefits, which is SSDI, and then we have supplemental security income, which is SSI. This is probably where most of the confusion lies. Which one is which, how different ones impact the other, because when you're talking about it with your neighbor, their experience might be on SSI and they're giving you that kind of advice, and you are on a different program, but it's all under Social Security, so that's where the confusion begins. We'll also talk about the application process and what you go through when you're applying and what you can expect at the disability hearing. Spend some time on that because if any of you have been through it, most likely you won't be denied until you have to present your case before a judge. So most people that are awarded, they're awarded through a disability hearing. I'll also give you some tips for applying, and we'll also talk about what's next after you've been approved, what you should expect after the case is done. I have set aside some time for Q&A. If there's something I don't cover that's of interest to you, please feel free to ask me about that, and I'll do my best to be as responsive as possible. So disability benefits, as they're defined by Social Security, are for individuals who are not able to work due to a physical or mental impairment or combination of both. And when I say they're not able to work, Social Security defines that as not being able to engage in substantial gainful activity. The abbreviation for that is SGA. You may have heard that word being thrown around, SGA. SGA is a technical term of art, it's a legal term of art, that basically means you are not able to engage in work that is beyond part-time hours. We're looking at about 20 to 25 hours a week, and you're not able to gain more than 1,090 per month. Now that amount, it changes every year with inflation. It's what we call cost of living adjustment, COLA. So every year we expect that amount to go up a little bit. Now, there's 2 different programs in the Social Security system for people who meet that definition. There's regular SSDI, which is Social Security Disability Benefits. That's for individuals who have worked 5 out of the past 10 years. So they have 20 out of the past 40 quarters of fiscal quarters, they have worked 20 quarters. They've gained work credits through the Social Security system by the taxes they've paid. Usually you're paying these taxes as a federal retirement plan for yourself so that when you hit the age of 65 to 67, you take that out as your retirement. However, if you're disabled, you meet that medical definition that Social Security has laid out, you can ask for that money to come in sooner in the form of a disability check. How much you get depends on how many years you worked and how much you paid into the system. That's SSDI. The other plan is SSI. That's for individuals who perhaps have never worked, but more importantly, their financial situation is below a certain level that so the government gives them these benefits despite the fact that there's been no work activity. Even some of them may have had work activity, but just not enough for it to amount to much. We're looking at both your assets and your income, and we're looking at the entire household. And when I say household, I don't just mean your spouse or your children. It could even be your neighbor, or your roommate, or a girlfriend or boyfriend, whoever that's living with you, your grandma or past that you're living with. They really consider the entire household. And we're looking at, asset-wise, we're looking at about $2,000 for single individuals, $3,000 for a couple. Mind you, your home is excluded and one car in the household is excluded. It's not a whole lot. I mean, most people, no matter how badly they're off, they may be able to find about $2,000 of assets lying around the house, even if it's not cash in other format. So you really have to be in a really tough position to get SSI. There's also the income test, which is based on how many people are in the household, how much income is coming into the household, how many people in the household are getting other government benefits, and then we work on a chart where they basically find where your household income falls within that graph. That's a much more technical discussion that we have when a client comes in. And sometimes if you fall very close within that income level, we may just apply and see where Social Security finds us in their chart. But it is important to understand these technical differences between SSDI and SSI, because although their medical definition is the same, they have big financial differences technically. So I'm going to go over that with you guys. And I know that the font is very small in that. I have given Lucinda this graph and everything else that I'm presenting to you, so you guys will have access to this. So I apologize, don't hurt your eyes trying to take notes on that. But basically, so they do have the definition of disability in common, which again is based on work engaging in substantial gainful activity. The work credit requirement does not exist in SSI. It does exist in SSDI. The financial restriction does not exist in regular Social Security. It exists in SSI. And the amount of disability benefits you can receive, if you're looking at regular Social Security disability, again, it's based on how many years of work you put in, how much you were paying into the Social Security tax system during that time. If you're looking at SSI, that is a set amount, that is the max amount that everybody can get, and that's $733 for the year of 2015. Again, that amount is adjusted every year to account for inflation with the cost of living adjustment. So every year we expect that amount to go up a little bit, but keep in mind that for every bit of income that's coming into the household, dollar per dollar, it will offset your SSI. So although the max is $733, not everybody may not receive $733 depending on what you're getting. The big benefit of individuals that want SSI, and I think it would be most interesting to people in this room, is the health benefits and health insurance benefits that it comes with. It comes with Medicaid. Regardless of your age, you get Medicaid with SSI. If you're not familiar with Medicaid, Medicaid is a state-funded health insurance plan that the federal government also pays into. But typically Medicaid covers all costs. If the facility takes it, it covers you for everything. Medicare is the other health government-funded insurance plan, and that is for SSDI. That's for regular Social Security disability. And that has an age requirement. You have to be 50 or older, or you have to have hit retirement age. So if you want to get it at the age of 50, you have to be found disabled. If you're not disabled, you have to wait till retirement age to get Medicare. Medicare is federal government, it's not state government, so it's treated the same across the entire country, whereas Medicaid can change when you move from state to state. When you get approved for disability, regular Social Security disability, it takes 2 years after your date of disability to get the Medicare started. Usually, because this process is so long, by the time you've been approved, that 2 years has already passed. So we may be able to go get something retroactively. Whereas with SSI, the day you're approved, it starts. It starts with the date of application. So Medicaid doesn't have that waiting period. Benefits for children. Regular Social Security disability does not offer any direct benefits to children unless their parents are approved, because they haven't worked. I mean, if they're under the age of 18, they most likely do not have a work credit in the system to gain anything. Whereas SSI, if you're under the age of 18, you can get it if the household falls within the financial parameters we discussed. Now, with regular Social Security disability, if you are a disabled individual who is receiving benefits and you have children under the age of 18 that belong to you, which are the guardian of, your biological children, your adopted children, they will be entitled to auxiliary benefits. So if you're receiving $1,000 a month, Social Security will add another 50% on top of that, another $500 on top of that to your children. So that is available to regular Social Security individuals, but a child cannot ask for Social Security disability benefits, they can ask for SSI. And as far as, this is one of the most common questions we get in our office is, can I work while I'm on disability? And I appreciate that question a lot, because it's one of the big mental challenges of my clients is not feeling productive. You've gone, perhaps had a career, you've had a background, you've taken pride in, and then when the health goes bad, you just don't feel as productive, and that is when the mental side of this thing really kicks in. And you can work, but it's, again, has to be under SGA. So you can work part-time hours, and it has to be below that $1,090 per month. Now, keep in mind, if you are doing something on a part-time basis that's very heavy duty, like a truck driver that's doing shipping and receiving and helping facilities out, they are going to wonder, well, if you could do that on a part-time basis, who's to say you couldn't do a sit-down job on a full-time basis? So when we get to court, we will very much have a conversation about the type of work you were engaging in while you were claiming disability and what that says about your functional abilities. All right, so let's discuss this application process. That's probably the most tedious and technical of it all, and I swear I think it's rigged. So nobody from Social Security will ever tell you that. They will give you all sorts of rhyme and reason for why they put you through this, but my personal belief as an advocate is they're making it difficult because they're overworked, they don't have enough funds, and they're putting us through this process just to catch up. But you file an initial application at the local Social Security office. You can find your local Social Security offices by going to ssa.gov and just putting in your zip code. You can do this by going in person in the office, or doing it over the telephone, or you can do it online. If you do an SSI application, you cannot do it online. They need to speak to you, or they need to see your face. I really, really recommend that if you're going to do this in the office in person, call them ahead of time, make an appointment. If any of you have ever sat around in a government office here, you know what I'm talking about. You don't put yourself through that. Make your appointment, go in, take with you any medical documentation you have that speaks to your diagnosis or your symptoms. Some of you, if you don't have a diagnosis yet, you can still take with you records of you complaining about your symptoms to your primary care or your specialist. But take something in with you. Do not count on Social Security doing this work for you, especially with KLS. This is something that is way above their head. They are not, their local workers are not going to spend their time researching this. You're lucky if you find that kind of an adjudicator, but you won't find it. It's going to be a quick rubber stamp denial, basically, is what I'm telling you. Few adjudicators will take the time to educate themselves on the application and the disease that's before them. But the other question, the issues that you need to be aware of during the initial application is your work history. They're going to want to know what kind of work you engaged in the past 15 years. And when I say 15 years, I'm talking about 15 years prior to your date of disability. Your date of disability, I know, is difficult when we're talking about a disease like KLS, where you don't exactly know when it was diagnosed, or was it at birth, was it later on. Typically, if it's for an adult, we look at time when the individual decided, I can no longer work. I'm just not being able to be productive at my job, or we got fired. If we're talking about a child, we either need perhaps a point in time that if the diagnosis was made, a point in time where the records are just become overwhelming. And that may be more of a legal issue that the attorney and the judge at the hearing have to hash out of exactly what is that turning point that we meet the definition of disability as far as the medical evidence goes. So you want to have that work history with you, you want to have doctor's records with you, you want to have an understanding of what your day-to-day looks like. They're going to ask you about your daily life functioning and how you cope throughout the day, how you can take care of yourself. More importantly for KLS, they're going to want to know about the frequency of the episodes, how long the episodes last, any recovery period that is associated with any other associated symptoms. So I always tell my clients, keep a journal, document everything as much as you can. Hopefully you won't have to go through this process, but if you do, it'd be really good to have everything documented. It will also help figuring out your date of disability, because your date of disability will coincide with how far back Social Security will give you as far as back pay goes. And I'll get into that in a little bit. So we'll file the initial application. 3 to 5 months later, we usually get a decision. That decision typically is a denial. It's an overwhelming number of people that get denied. And that decision is very informal. It's very impersonal to you. It sounds like nobody even looked at what you told them. Nobody even reviewed them. It's very much, well, we find that although you said you can't, drive a truck anymore, you could still go be a teacher. Just something really nuts up like that. Like, what are you talking about? But it's really just a standard language that I think they have a template on. They're just plugging in the information and just spits it out for them and they issue it. Once we get that initial denial, we have 60 days to file an appeal. We want it in our office, we do it right away. We have 60 days, but this is going to be a 2-year process. Why do we want to sit around for 60 days to file an appeal? So we file it right away. It's called a request for reconsideration. And at that level, if they haven't already sent you to one of their own doctors, they may send you to one of their doctors that basically will examine you and just have a conversation with you about what your functional limitations are. And listen, if you had back problems, that appointment might have been helpful to you. It might be helpful to see a doctor from Social Security side that asks you to bend over, maybe asks you to raise a leg, whatever. With what you guys are dealing with this appointment, it's going to be completely useless to you. And it's going to reveal probably nothing to Social Security. Already the medical industry is so far behind on research and understanding what's going on with KLS. So imagine these government-funded doctors, what knowledge are they going to have about it? Because they really don't have any resources to research this and look into your specific issue. Usually these are just generalists that they send you to. But you need to really, they ask you to go to the appointment, you need to go, otherwise they'll give another quick denial just for non-compliance. We typically expect a second denial at that reconsideration level because it's gone back to the same hands. And I'm telling you this not to discourage you, I'm actually telling you this to encourage you to not get a denial and just stop right there. You have to keep going. And when you get that second denial, then you need to ask for a hearing with the administrative law judge. And that's where the hearing comes in. And in Georgia and Atlanta right now, we're looking at about 12 to 14 months from the time you ask for a hearing to actually get a hearing. So this is really where I'm talking about a 2-year plus process kicking in. Most people that have a good case, they win it at the hearing level. They win their case at the hearing level because the judge really seems to pay attention to what's going on. But if that still does not result in a favorable decision, then we can appeal higher to the Appeals Council in Falls Church, Virginia. It's a tribunal judge that sits there and basically they review whether the judge made the decision in accordance with the law or not. They have an option of reversing the judge's decision, remanding it back from the judge's decision, or just denying it altogether. That's not a very easy process to overcome, so hopefully, you've won your case in the hearing process. And if you still get denied at that level, you've really exhausted all administrative processes, and then you get to have a lot of fun and sue the whole agency and U.S. District Court. I'm kidding, it's not fun, but it is an option. So here's what I want you to know about the hearing. I understand it can be very intimidating for a lot of people to go into a room with strangers and talk about some of the most personal information about you. It's already intimidating to go to a doctor for the first time, supposed to treat you, let alone going before a judge. But the first thing I just want to tell you is, you asked for this hearing. You're not in trouble. It's not like regular court hearings where you're being sued or you're about to go to jail or something like that. You're really saying, Social Security messed up, hear me out. But you really do need an attorney at this thing because it can be very technical. But the most important thing to keep in mind is this is your chance to tell the government what's going on with you and why they're wrong and not giving you the benefits that you are entitled to. And the people you can expect at the hearing are just, it's very informal, it's not open to the public, so the only people you'll see in the hearing room is you and your attorney. There'll be a judge who's an administrative law judge, and they specialize in Social Security. That's the only area of law they deal with as well. Typically, you'll see a vocational expert, which is basically a job expert who will talk about what your previous work history means as far as your physical and mental skill level. Sometimes the judge will invite other witnesses in, such as medical witnesses, doctors, who can explain to the judge the specific things in the medical record means, or explain if the medical record meets the definition of Social Security, as Social Security's laid it out. I would say, specifically for KLS patients, your own witnesses are really important, and you will rarely find me telling clients that, because I don't have a lot of clients that deal with symptoms that deal with memory issues or loss of time. But when I have clients that have severe epilepsy or any other neurological diseases, I do tell them, bring in a witness, a family member, a roommate, somebody that knows what you're going through when you're going through an episode, and what your recovery looks like. You are probably not the best witness for that. Your family, whoever you're living with is. And I think that would really paint a much better picture. So one thing I would say differently to KLS patients than most of my other clients is have a family member witness. If they can't come, have as many people that have witnessed you go through this write a letter and explain what they see. It's usually better if they come in, but if they can't, I'd be glad to take a letter from them as well. The judge's role in the hearing is to be an impartial adjudicator. Basically, they will swear you in, ask you some background information, make sure you are who you say you are, and then they will go over any legal technical issues that are really boring to you, but really important to the attorney and the judge to take care of, such as, is your date of application coincide with your onset date, you fall within the right parameters of the different programs, and that sort of thing. But your most important part in your hearing is your testimony, and your attorney should really well prepare you for that. That's when you want to give direct responses to your attorney or the judge, if the judge wants to ask questions as well, about your symptoms, your episodes, again, what the episodes look like, how frequent they are, how you, if you were working and you had to come out of work, how work looked like while you were going through this, your day-to-day life activities, how you can function with this disorder, and so forth. And based on your testimony and your medical evidence and your job history, we will then turn it over to the vocational expert. And the judge will basically ask the job expert different hypothetical scenarios where they say, I have an individual of the same age, education, and work history as this claimant, and this person needs two absences in addition to regular absences throughout the day, or they need to take 2 weeks off in the year randomly without any notice. Does that allow for them to go back to what they used to do? The answer to that is no, which I think should be no. Then we have to ask, is there anything else they can do? Because keep in mind, disability doesn't mean you can't do what you used to do. It means there's no job out there that would accommodate your impairments. And that pool of jobs we're looking at diminishes the older you get, because Social Security recognizes that there's something called a vocational adjustment. The older you get, the harder it is to adjust to a different work setting, to a different industry, to different training tools, and so forth. And Social Security rules are a bit outdated, so they consider a 50-year-old to be approaching advanced age. As offensive as that could be to a 50-year-old, it is good news when you're dealing with the Social Security Administration, because then they can't consider that you can do anything else. They really have to keep that pool much smaller than they would for somebody younger than them. So, you know, it's the one time in life where you don't have to take offense to be an older individual, I guess. But at the hearing, typically the judge does not issue their decision. They take everything into consideration. They ask for another few weeks. They'll issue a decision to you and your attorney. And at that point, if you have a favorable decision, it means you not only get disability benefits on a monthly basis, but you also get back pay, which is a retroactive lump sum you get going back to the time your disability began. Again, I think that's going to be the sticky point for a lot of KLS patients, is when exactly can we pinpoint that the disability began. If you don't get approved at this level, you can go to the next level. So some tips, general tips for applying. Again, I keep coming back to this point of knowing your date of disability. If this is not something that is easily, a date that's easily attained for you because you don't have a clear diagnosis, this is a conversation you need to have with your attorney. Your attorney could look at if you are somebody that has worked, could look at your earnings records and see what point you stopped hitting SGA, to see if the medical evidence shows that you were complaining about symptoms at that time, and maybe connect the dots for you in an argument to the judge. If a diagnosis came out clean and clear, then great. That is most likely what the judge is going to use as your date of disability. Because again, we're dealing with the issue, with the diagnosis that they're not going to be very well prepared to discuss, and they're really looking for medical evidence here. You want to organize your medical and work history. If you don't have all your medical records, that's totally expected and understood, but what I really encourage my clients to do is take a little pocketbook calendar, and anytime you see a doctor, put down on that date of the calendar who you saw, the date of the visit, what you saw them for, if you have any outcomes from that, that visit, put it down, because your attorney is going to drill you on your medical history. Who did you see? When did you see them? What did they prescribe? Where can I get records from? And then you're going to ask you to update it. You're looking at a 2-year process, so we're not only looking at like the past 5 years of medical history before you came to the attorney, but really 2 years until we even get to the hearing. And same thing with your work history. Try to keep a record of that. If you have a resume, that would really help. I know I said there's going to be 2 denials when you get till you get to the hearing level. That may be very discouraging. The whole process is probably designed to be discouraging. But again, I file the appeals timely. I tell everybody that to expect a denial because I don't want them to see it and take it so personally as a lot of my clients do. It's very hard to have had a very productive life and had a good work and had a good education and get to a point in your life where you can't work anymore and not be productive, and then ask the government for the help that they've told you exists out there for you and money paid into the tax system, and then they're coming back at you and saying, you're not disabled. And how do you know me? How did you look into about me and my disease and what I'm dealing with in my daily life? You know nothing about me. How can you just come back and tell me, well, you didn't look hard enough for other jobs that are going to accommodate you? So everybody is treated the same way with Social Security. That's the one thing I can say, though. So don't take it personally. Just keep fighting them. Because there is a silver lining at the end when you get to the judge. The judge really will educate themselves on your case, on your medical evidence, have a real conversation with you and your attorney, and that's the day you feel like finally somebody from the government side listened to me. So hang in there. I really think the best cases are the ones where the doctor gets involved, especially when we're dealing with this. If the Social Security doesn't recognize your disorder, if the doctor has not been able to come up with a diagnosis for it, a doctor's word saying, this is what my patient has been suffering from on a regular basis, I've been treating them since they were this young, and so forth, and the symptoms that I've been dealing with, and so forth. Social Security will have to go by your doctor's word if that doctor's word is backed up by their own medical treatment notes. There's a rule in Social Security, it's called the treating physician rule. Your own treating physician gets the highest evidentiary weight than any other doctor that Social Security has sent you to, or that has examined your medical evidence, because they have a treating relationship with you and they know you better than everybody else. So, and we trust their opinion when it's backed up by their medical treatment notes. So don't be discouraged if you don't have an actual diagnosis. If there are treatment notes, that will help. And as I always say, financially and mentally prepare for a 2-year process. I don't know how easy that is to do. There's family members out there. If there are long-term disability plans that you can purchase into, I really suggest you do this. It's not very easy if you don't have a support system to get through this process. And I do not recommend anybody to go through that hearing alone. Not because the judge is going to be mean to you, but there's going to be technical issues in there that you may not be well equipped to answer, and you may end up with less. If you are going to get a favorable decision, you may end up with less than you could have received, or you may get denied if the judge is just not well aware of the technical issues that he should be aware of, or he's not paying attention to as an attorney should be there to make him aware of. So what happens after your case is approved? The monthly checks usually start 100 days after you get your notice of reward. That's just the monthly checks. The retroactive payment, the back pay, that can take months. Social Security says give us 6 to 9 months. We've actually seen it in our office come a little bit sooner than that, but that's the time that Social Security has asked for. There may be also representative payees, and this is definitely the case if you're talking about a minor. Somebody that is going to receive the checks on the disabled person's behalf, and they are responsible for making sure that the money goes to necessities. If you are a representative payee, please keep track of how you're spending that money. If the government comes back and wants to know, where to go, how's it being spent, any issues that they're having, you can just, keep a log or keep receipts and let them know this is how the money's been spent, and we're clean and clear. Disability reviews, and I think that's an important subject too for this group in particular. Certain disorders that either Social Security is not well aware of, or impacts people at a younger age and it gets better as they get older, as some of the KLS studies have shown, we are more prone to getting a disability review. What that means is after you've been approved, Social Security may come back in 2 years and review all your current medical records to see, have you improved, have the condition gotten better, can we take you off of this program? So if you are not seeing improvement, the way to show that to Social Security is continue going to doctors. Not seeing a doctor to Social Security means there's been improvement. I have a lot of clients that come to me and say, well, I can't see that doctor anymore because he said there's really nothing else he can do for me at this point. There's no more treatment. There's nothing he can help me with, so I don't see a point in seeing them. If that's your doctor's mindset and you want to get on Social Security, you may want to change doctors or have a different conversation with your doctor. It really is important that you continue to see a doctor if you want to stay on Social Security. No treatment means improvement to them. That's just the default rule they go to. So I really encourage, specifically for the KLS patients, continue to see your doctors if you're receiving disability. Okay, do we have time for Q&A still? Great. Any questions? Yes, sir.
I'm not sure if you can answer this or not, but I have applied for FMLA through my work and I have been denied because of the knowledge they received from doctors. Is that capable of being approved? How can I go about to get approved? That way I can take off without missing any discipline or work for my daughter.
I'm not an FMLA attorney, but, so this will be like friendly advice, okay, not legal advice. You need to see an FMLA attorney and they need to appeal it for you. Are you in Georgia?
No, ma'am, I'm in Pennsylvania.
Okay. I know a great one here in Georgia, and he travels throughout the country and gives speeches on long-term disability and short-term disability. I'll be glad to take down your information and connect you guys, and he probably knows somebody in your area that he can connect you with. At the very least, you may be able to get a consultation.
Thank you.
Over here.
Can you speak to the importance of listing other diagnoses of behavioral health when applying for SSI?
Any other importance of what?
The importance of listing other diagnoses, behavioral health problems, things of that nature.
Yeah, I mean, if you definitely do not want to limit it to just the KLS. If you have other diagnoses, if there's a mental component, you should definitely bring that up. If you're getting the therapy, we need to bring in that psychiatrist or psychologist. Absolutely, you don't want to limit it. If you haven't been diagnosed with KLS, but you have been diagnosed with all other things that are associated with KLS, we need to list those doctors, and we need to list those impairments as severe and discuss how they can get functional limitation. Because great question, if the KLS is just not sticking to the judge, maybe we can win this on a mental case.
How is the legal representation paid for?
It's actually 100% contingency fee. So Social Security regulates your fee agreement with your attorney. And the rule is they can only get paid through your back pay. That's the retroactive lump sum you get for the time that you should have been awarded and they've been dragging their feet. Not from your monthly benefits. Your monthly benefits do not get touched. It's 25% of that back pay. That 25% cannot exceed $6,000. So it's either 25% or $6,000, whichever is the lesser of the two. And myself and most other Social Security attorneys I know, they do give a free consultation. So my advice to you is, there's no need to do this on your own. It's pretty much free to you. And if you meet an attorney that's told you otherwise, report them to the bar, because this fee agreement is really governed by the Congress, actually.
If you're currently covered by a certain type of health care, how does Medicaid actually integrate with that other health care?
If you have other health care, you can most likely you would be able to keep it, but you have to check with your state office on that. How the state differs on that.
Do you know of any lawyers in Texas?
I think I do. So if you want to take my card and send us an email, we'll send you a referral. This is also federal law, by the way, so any attorney can, with any state bar license, can practice anywhere in the country. We have cases in Tennessee, Alabama, Florida, but it just matters if the attorney wants to, if they have something out there, if they want to come out there for you. So you're not limited to your state, but I do think it's better to go local, because you do want your attorney to have a rapport with the judge, and be dealing with the same judges all the time, or dealing with the same local offices all the time. So I don't recommend going with like a big national law firm who advertises on TV and they say we take the case out of anywhere in the world. I think you're much better off getting a one-on-one with your attorney, and your attorney having a one-on-one with your judge as well.
So please feel free to contact her.
Yes. We do have, I try to stay connected with other Social Security attorneys in the area, so I know a lot of people here are not from Georgia, so I'd be glad to help you guys find somebody in your area if you need to do that.
The nice thing is you don't have to explain what KLS is.
Sarah, do you have cards outside?
I do. I have cards outside. We send out a monthly newsletter. We're also putting out an ebook. If you guys just want to sign up, put your email down, you'll get our monthly newsletter to your email, and then we'll send you our ebook when it comes out. And if you at any point want to unsubscribe to any of it, you can do that too when it comes to you. So, but feel free to sign up. Yes, sir.
I was going to ask, a lot of them get this KLS as they're younger, but then they will roll older, maybe go off to college or job or whatever. How does that kind of process play out as far as when do they become eligible for different benefits potentially, or not, or what?
That's a very good question. So if they're going to receive it as a child, it's going to be SSI. And the trouble with child SSI is the parent's income and the parent's assets are counted against the child. There's special needs trust you can set up, where you can put money in a trust through a trust and a state attorney, so that your assets do not affect your children's ability to get SSI. But let's say the child got the SSI and then they turn 18. If they turn 18 and they're still not able to work, we can get them SSI on their own, and then no longer will the parent's income or assets affect them. But if they're going to full-time college and they're attending classes on a regular basis and having no trouble being a full-time student, when we get to the legal part of it, of me having a debate about this with the judge, it is going to be challenging, because the judge is going to say, well, he or she can be a full-time student, attend college, take care of themselves, and not miss any classes, excessively. Why can't they work? So we would have to show for a college student. We do have college student children in our client base, but we do show all the accommodations they need to stay in school. Maybe they have a completely different understanding with their teacher. The teacher is accommodating them in many ways. They may have to take online classes because regular attendance is not a possibility for them, and so forth.
I just want to dovetail on that. If you have a child who is receiving SSI and they have a 504 plan or an IEP plan, the accommodation page, and I'm going to talk to you about that a little bit later, that would be very important, I would say, to give to you so that you can show those accommodations.
Absolutely. I'm glad you mentioned the IEP. If you have children who have KLS and they're an IEP, the IEP reports are probably just as important, if not more important, than the medical records. we really sit and just dwell into how they're performing at school. That's a big conversation we have. And I even send out questionnaires to their teachers, and I ask their teachers how they're doing in class, and so forth. So thank you for that point.
Hi, we're from Pennsylvania, and I just went through this. We had been rejected the first time, and they said that the only way we could get it is if the doctor told me I could not work anymore, which we actually did. We had my own medical doctor, plus my psychiatrist, and also Cleveland Clinic. And with all that, they accepted us, and I just started getting it in March.
That's great. That's great. And you fell into that treating physician role. That's why your own doctor's word is so important. Whenever somebody comes to us, the first thing we ask is list us your most important doctors you have the best relationship with, and we get forms out to them right away, what type of forms that you're describing, or asking for day-to-day functional limitations. And I think it's important to not only ask the doctor to fill out a form that you've already created for them so that they kind of understand what Social Security is looking at, but also ask them, please feel free to write a narrative statement. Some doctors want to do both, some don't feel comfortable just checking boxes for an attorney, so they want to put their own word in. But most important, if you're getting a letter from your doctor writing, he or she is disabled is not going to work. That's actually going to be ruled out. They have to explain functional limitations. But I'm so glad for you didn't have to go through the entire process. Good for you. No more questions?
Okay, thank you very much.
Thank you.